There you go. Court does call the case of the people of the state of Michigan versus Jules, is it Calhoun?
Ron Brown on behalf of Mr. Calhoun.
Andrew Childers appearing on behalf of PPR.
Your name, sir?
Jules Calhoun.
All right, thank you. All right, this is the, it's entitled People's Ex Parte Motion for Modification with Bond Conditions. I don't know that it was as filed ex parte in any respect whatsoever, because I think it was communicated to all parties. That's the first problem. The other issue is that typically these motions are filed. Court's first determination is whether or not the necessity for the court's action constitutes an emergency. I'll be frank with you, I'm not convinced that it does constitute an emergency, but given everything, the court is choosing to hear the matter. I really don't deem it an emergency, so that you're clear on the court's perspective. All right, but is your motion? Go ahead.
All right, before I begin, and thank you for that, thank you for accommodating this motion. Because I'm a little unclear. I talked with Ms. Higgins and Ms. Scott from the defender's office. My understanding is there was one order, and I think there was an error or an issue with what are specifically the defendants with respect to the GPS tether and exclusion zones. What are those conditions if nothing changes with respect to the defendant's bond as we sit here today?
The original order that was entered by the magistrate on the 28th, and I'd have to go back and look at the hearing, but I don't know that there was necessarily an objection from the people, was for location tracking only on a GPS tether.
Okay.
That subsequently, and and again, I'd have to go back and look at the hearing. I did not have the time to review the video of the hearing. That has subsequently been changed to exclusion zone with location tracking only. So the change wasn't to, well, just added an exclusion zone. And the only area that was added, which again doesn't, when I look at the requests, the written requests that were made by the people, doesn't make much sense to the court, given my knowledge of the area, is the address of Hazley Elementary School, Ann Arbor. That particular address is the hot zone.
Is Hazley Elementary School.
Is Hazley Elementary School.
And so that, as the order currently stands, if the defendant were to be released, there would be exclusion zone of the elementary school on its GPS tether.
As I read this order, yes, but again, given my knowledge of the area, I have concerns about how this is written. Because, and I'll just lay it out to you. I mean, I'm one that is full disclosure. Hazley Elementary School is my elementary school. I know people didn't think it existed way back with the dinosaurs, but it did. There are 4 entrances to, basically 4 access points to the Hazley School grounds that come off of different neighborhood streets into there. So listing just the address, I don't know, quite frankly, is specific enough to cover the area. I mean, for the most part, most of the people that, if they were walking there, would not enter necessarily off of Duncan Avenue. They just, so that's what I have.
Okay, and thank you for that, Young. I know, obviously, we were with with each other less than 24 hours ago.
We were.
Court operates that's why I wanted, before we get into anything, I just wanted to make sure that my at least as correct as it could be. So the motion that was filed by my office last night is requesting a $2 million bond with the otherwise with a house arrest with GPS tether release, and for him to not be within a mile of any school. That would be the request. The concern, my understanding, the concern that gave rise to this renewed request, because at the time of the arraignment, that was not the request of the people, was that the learning of the defendant's.
Well, let me just stop you because I don't think that that's true. At the time of the arraignment, and this is something, quite frankly, that people are going to have to explain to this court. There was an original bond request sent for, in terms of its monetary amount, for the $250,000 cash surety. That was, as best I'm able to determine, sent on the 17th. Or shortly. The original one for the $250,000. Within 5 days, there was then a new bond form for the $2 million with some other added changes. I've, as best as I could on short notice, reviewed those. What I do not understand is, and just so I'm clear, so at the time of the defendant's arraignment, both of those.
The court reviews the prosecution's motion to modify bond conditions, questioning whether it was properly filed as an emergency and expressing doubt that it meets that standard. Attention turns to confusion surrounding the defendant's GPS tether conditions, particularly the addition of an exclusion zone around Hazley Elementary School. The judge raises concerns that simply listing the school's address may be insufficient, given the multiple access points to the property and the judge's personal familiarity with the area. As the discussion continues, the prosecution clarifies that it is requesting a significant bond increase to $2 million, continued house arrest with GPS monitoring, and a restriction preventing the defendant from coming within 1 mile of any school. The court challenges the sudden increase from the original $250,000 bond, noting that no new facts appear to justify such a drastic change.
Were before the court. For the magistrates, both bond forms. This request for the $2 million was before the court at that time. What could not be explained, and I think something that's going to have to be explained by the prosecution, is why the request, particularly for the monetary amount, is changing. Because I don't see any basis as to why, in essence, almost an 8 to 10-fold request for an increase in those 5 days when there's nothing that happened. There's no indication of any other information that came to light that might justify that.
The only response I can give to the court would be to rely upon the written meetings. I have no personal knowledge or information.
Well, okay, and I get that, but isn't that important? I mean,
I don't disagree with the court.
Because effectively what you're asking me to do is to do something under the court rule, which I can't do, which is to deny the defendant bond. I mean, a $2 million bond will be effectively a denial of bond for this individual, from my understanding. I've had my mini tirade. You can go ahead.
I understand the position of the court. As I stated, I'm relying upon the pleadings that have been filed. I think that at this point, I would move my discussion on, if the court's willing to an exploration of modification of the GPS tether. Or at least clarification, hearing what the court, through its own personal knowledge and experience of the location of Hazley Elementary and the location of the defendant's residence. My understanding is that there is perhaps a residence the defendant can stay at his uncle's home on, I believe it's Ingalls, just kind of other, slightly more downtown, you could say. Now, in a quick look on Google Maps, that address does appear to be within a couple blocks of Community High School. I don't know if the court is would entertain. I'm just kind of, as we do sometimes, Your Honor, exploring options on the record.
Right. No, I got you.
And so, that's kind of where what I'm looking at now. Ultimately, we have a lot of people in the courtroom. I believe the majority of these people in the courtroom are staff at the elementary school that were affected by this threat. They are concerned for their own safety. They're concerned for the safety of their students. Rightfully so. I have a child in elementary school, and the court has its own experience as such. I think that what ultimately we're looking to do is anything we can do, acknowledging the fact that the defendant may very well be out of custody while this matter is pending, that we can as best protect the children of that school and the community at large. And that's what the people are requesting. And I'm open to a discussion as to how we can best do that. And I'm very much aware of the defendant's history. I guess I wouldn't say I'm very much aware, but I'm aware of the defendant's both mental health issues and what I could say the condition that he exists in, through a brief reading of the police reports, as well as discussion with members of the public defender's office. I'm aware of all of those things.
Okay, so, and then certainly I'll hear from the defense, but there was a request that he not go within a mile of any school, right?
You have to leave the city of Ann Arbor.
Absolutely. I mean, because I even this morning was having my staff look and just try to determine whether or not that's even a feasible condition I could put on a defendant. And a mile, you can't do it. I mean, I think within really a mile and a half, 2 miles of just Hazley School, there are two other elementary schools and a junior high and a high school. So, I mean, I don't even know how that would work, to be honest with you.
Would the court consider a GPS tether with house arrest, so we don't have to play the exclusionary zone game?
I would certainly entertain it. And look at it if that's the request. And Mr. Childers, I realize you're here, and I always respect the arguments that you give, and you always give good arguments to the court. I'm trying to figure out what specifically are the people asking the court to do. Because when I look at the motion, the request is really threefold. That the people want his bond increased to $2 million cash as surety from the current $250,000 cash as surety. They want him to remain under house arrest with a GPS tether if he's released, and that he can't go within 1 mile of a school. And so, I mean, is that the people's request, or?
Be possible if we could take a brief break. I didn't file the pleadings, obviously.
I know, Mr. Childers, and I understand that sometimes we're put in a position of having to argue something, but so that you're also clear, I mean, I take what is at least alleged the safety of the students, the safety of the community very seriously. I can tell the people out there that people that have known me, I've been on the bench 25, 26 years. You can send me all the emails you want. It doesn't affect it. I'm going to issue my decision based upon how the law reads. So you can stop sending the emails because, quite frankly, they don't get to me until afterwards, and they have no effect on me. I need to know what the people want, what the defense wants, and then I'm going to make the call. And there are going to be those that don't like it. There are going to be those that like it. Doesn't, but that is irrelevant to me in a lot of ways. I'm not here for a popularity contest. And I think there are some people that need to realize that in terms of what they file before this court. I don't play a popularity game. I do my job. I will give you a break. You can take the defendant back and we'll come back out and I'll hear from the people and the court stands in recess.
All right.
Andrew Childers appearing on behalf of the people.
Ron Brown appearing on behalf of my client, Your Honor.
Right.
Thank you, Your Honor. I appreciate the opportunity. I've spoken with the chief assistant, the elected prosecutor, and the position that we are requesting, I would call it modified off the written pleading. What the people are requesting is and I don't believe in my discussions with the public defender's office, this is something that they're opposing. The house arrest at the uncle's address on Ingalls. So it would be a GPS tether with house arrest. Commander Shipakasi from the jail has been or is currently in communication with the deputy chief at Ann Arbor Police and working with the uncle to have Ann Arbor Police go through the residence prior to the defendant being tethered there to ensure there are no weapons in that home. And I believe that we would allow the defendant has medical appointments at CMH and a doctor. We can figure out those details, but we would allow for release to verified medical appointments from the Ingalls Road address.
Right.
That's correct, Your Honor. We'll figure out the details and present an order to the court.
Well, you'll figure out the details of the appointment.
We have the appointments in the address. 2 at CMH and 1 with a Dr. Connolly, whose office is at 3300 Washington Avenue right now.
But are those regular appointments? So they're going to occur at a particular time or what?
Through today, for the next week, we know of these appointments. But once he's seen, we don't know when he will be seen again or scheduled again. They're intake assessments.
Thank you.
And my understanding.
That's right. What did you hear?
I'll go sit down.
You know what? Oh, no, you're fine. I'm just saying. I knew somebody knew something more than most.
Of course. Usually in my experience, if we allow for them to, there can be an aspect where the defendant is communicating with community corrections.
Correct.
If this particular doctor, I know appointments change and things like that. We don't need to have an order reflecting every single appointment. But the people we would have no problem provided they are verified with the defendant seeking the treatment at CMH and with his doctor.
All right. So just so that I'm clear, the request for the increase in bond monetary amount is withdrawn.
We're no longer making that request.
The request for exclusion zones is not needed only because he'll be under house arrest.
Right.
All right. And then what did I say the other one was? All right. So really the second one is just a modification of GPS tether to a house arrest.
House arrest, correct.
All right.
And Brandon Casey from Community Corrections was already sending me messages that they're aware of this address and
They're aware of the Ingalls address?
Correct.
All right.
Your Honor, we've also spoken to the owner of the 110 North Ingalls address, and he has consented to the police search of his home for weapons.
All right, and that's a single,
It's an apartment, an apartment.
it's an apartment. Council approach.
Another-
All right. I'm gonna have to pass this matter again because I gotta figure out one thing about the location and address. So we can take him back and I'll pass it. Ms. Pearson, feedback in.
Yes.
As the hearing progresses, the judge emphasizes that a $2 million bond would effectively amount to a denial of bond, which raises serious legal concerns. The court openly questions the feasibility of enforcing a 1-mile school exclusion in Ann Arbor, given the number of nearby schools and the impact such a condition would have on any possible residents. While acknowledging the fears of school staff and community members present in the courtroom, the judge makes it clear that decisions will be based strictly on the law, not public pressure or emails sent to the court. The matter is paused to allow clarification of the prosecution's exact request, with the judge stating that after hearing both sides, the court will make a ruling grounded in legal standards rather than popularity or emotion.